Hello. Today I'm going to discuss whether hiring a former AUSA or prosecutor, private counsel, or federal attorney, which is best. Hello and thank you for tuning in to the ninth of my video series, Indicted and Facing Prison. Now what? My name is Mark Gladstein, and in 2006, I was indicted and pled guilty to a felony and lost my license. Several years later, in 2010, I was able to have it reinstated in full. But to call what I went through and what all of you are now going through a surreal experience is a definite understatement. My goal here in this series is to provide you with the crucial information you'll need to survive and navigate these times. I'll provide you with a new topic daily so that you can move forward, because knowledge and preparation result in building your confidence that you'll need to get the best possible outcome. Since you're already aware that the Department of Justice and the Feds have been asking questions, their case against you is mostly complete, and with a greater than 95 to 98% conviction rate, the odds are that you may have to spend some time in prison. Knowledge is power, and now it's in your hands. Delaying to take the next step is at your peril. The consequences of inaction can be severe, and you don't want to have regret. Equally important is hiring a legal team. And they can be great, but if they just have experience, but not a proven track record of successfully defending cases like yours, your future's at stake, and it's crucial for you to make the right choices today. Should you have any questions, please do not hesitate to call and consider engaging my services at 240-888-7778. This is your future in your life. It's important to interview attorneys before you have your legal team in place. This is your life, and you don't want any regrets. I hear too many conversations where either they didn't ask questions, the lawyer wouldn't return phone calls. Whatever the issue is, it's better if you understand this up front. So in life, there are good and bad auto mechanics. There are doctors that are not so great and other doctors that are excellent. So too, there are great, not so great attorneys. And it may not have anything to do with how great they are as to where their experience lies. But there's only one way to find this out, and that's asking questions. Asking questions can help you learn if you're a good fit for each other. It's important to learn if they have experience in practicing federal criminal defense in federal court, which is much different than state court. Do they have experience in cases like yours? You may want to connect with their state bar and see if they have had any disciplinary problems, but this is not a deal killer. Also, do they have a proven track record? Will they be able to provide several current or past clients for you to speak with, ease some of your concerns? Nobody's happy going to, after coming out of a confrontation with the feds, because most go to prison, but they still can provide insight into their comfort with the attorney. Would they be willing to provide several sentencing memorandums for cases like yours for you to read? And if they bring up HIPAA, which is a privacy law, it's true. Just let them know that you're also familiar that Adobe PDFs allow for redacting of all personal information, and that works a lot better than a black magic marker. Then when you're reviewing the memorandums, you want to see if they all look the same. If they do, that's not good. Each of the memorandums should be focused on their defendant and centered around the points regarding their defendant, in their particular case or their client, the statistics that support the attorney's recommendation for departure below the guidelines, and not be all just legal jargon. Additionally, you should know if the charges are going to be hourly or if they're flat fees. And if so, is there any sort of payment schedule option? If you're already at this point, you don't have the time to wait to view my future videos, give me a call. We can discuss your situation one-on-one. Once again, my number is 240-888-7778. If you want to go to trial, just know that feeling that you're in the right is not enough. Also, it's okay to go to trial because 0.2% may come out victorious. What you don't want to do in trial, though, is anger the judge, like Sam Bankman-Fried did, where they had to take him off of pretrial release and incarcerate him in a detention center for witness tampering. Then don't forget that when you go into trial, that the Department of Justice has this 98% conviction rate. So if you're in the right and you feel strong with your attorney and you're comfortable, you can go to trial, because if you lose, everything is not lost. You can still apply for leniency, doing the right things before sentencing. What you don't want to do is alienate that same judge that you'll have to come back to later and ask for leniency. Further, some strategic questions. You want to ask the attorney, if you're considering trials or appeals, how many have they won? Just ask them outright. In the past 3 years, in the past 5 years, what is your percentage rate on winning appeals or trials? Because they can't be high in the federal side. How big is their current caseload? If it's a small practice, single attorney, and they have 2 to 3 cases a year, that's enough to keep them busy. Will they, they'll be working with you full time. Do they have the time? While not yet law, there's something called the Fairness and Restitution Act. If you have, or if you anticipate owning or owing restitution. The Fairness and Restitution Act it's not law. It's a project that's being worked on by the National Association of Criminal Defense Lawyers and a nonprofit. And they have certain key parts to it. But the parts I'm going to discuss right now is that if you're anticipating owing restitution, consider asking the court if you could show actual loss sustained by a victim as a direct and proximate result of your actions. 2, eliminate joint liability to ensure that defendants are only responsible for the financial losses they themselves have caused. 3, provide a right to an evidentiary hearing for proving or disproving the amounts included in a restitution order. And last, this they may not agree to, is request to change the statutory period of liability, bringing it down from 20 years to 10 years and preventing extensions. During the interview, ask them, when do they believe is the soonest you should begin preparing for your pre-sentence interview and to begin writing a well-written narrative? That's a big deal. The earlier, the better. And so you as a client or defendant should be beginning to do this yesterday. Do they believe in the importance of a well-written narrative and release plan? If they agree, then that's a couple points in their favor. When do they believe you should begin asking for character reference letters? That's as soon as possible. And these are letters regarding your character, not letters saying you're a nice person. To engage my services or to have your concerns answered, call me today at 240-888-7778. This is my personal cell, and I answer and return all of my calls. You can also get additional information on my website at PPRSUS.com. That's P as in Paul, P as in Paul, R as in Robert, S as in Sam, US.com. Thank you very much for tuning in today, and I appreciate you taking the time. Have a good day.